applies those same requirements to the process of mail-in ballots. So if you apply to vote by mail, you are also being required to supply one of those identifying numbers as part of that process. So
you're saying for a mail-in ballot, they can either provide their driver's license number or the last 4 digits of their social security number?
Or they can provide a statement that they have not been issued a number. In addition to the driver's license number, they can provide a personal identification card that's been issued by the Department of Public Safety, and that would have a number on it as well.
So you're saying if they don't have a driver's license and they don't have a social security number, that they can just make a statement as such?
Yes, sir, that is correct. That's current law for in-person voting, and this legislation would apply those same parameters to voting by mail. And then I would also point out that voting by mail is not available to all voters. Texas law actually has eligibility requirements for that.
Can you remind us what those are?
To be eligible to vote early by mail in Texas, you must be 65 years of age or older, be sick or disabled, be out of the county on election day and during the period of early voting, or be confined in jail but otherwise eligible.
Are there certain cases where an individual can even use an expired driver's license?
That is correct. Current law allows for you to use an expired driver's license, and in the bill, express language also incorporates that fact.
So in summary, because we've all heard from Texas House Democrats in D.C. that this bill made it harder to go through the mail-in process, but what I'm hearing you're saying is they simply need to either provide a driver's license number, last 4 digits of their social security number. If they don't have either of those, they can just state that they don't, or in some circumstances, they can even use an expired driver's license.
That is correct. And during the committee hearing on this bill, which you are on the committee and you heard from hundreds of witnesses, and we've also seen come out of the Senate, there is cure language to correct a defect on your mail-in ballot that's contained in the bill that you have before us. And also, I'll speak to that a little later with a perfecting amendment as well.
Okay. So tell us a little bit more. So you're saying that individuals have an opportunity to correct a mail-in ballot if there's defects? What kind of defects are you talking about?
Well, for example, if they send in a mail-in ballot and it doesn't meet the requirements so that it can be properly considered, the early voting clerk can actually return that and contact them and let them know that they can come in and correct the application or cancel the application and vote in person. So the point made here is, and also with the perfecting amendment, that we want to make sure that if somebody had an error or mistake, we want that vote validly counted. But we want to make sure that they have ample opportunity to correct what error occurred.
So literally somebody can make a correction after the fact. This legislation allows that.
As long as it's been determined that there is sufficient time to do so before the end of the voting period. Yes, sir.
Okay. It sounds like there's a lot of provisions that make it actually easier to vote, contrary to what we've heard. Contrary to what we've heard, there's been accusations about partisanship and the like, but is it true that there's significant portions of this legislation that are written by both parties?
Yes, and as I explained in my layout, consideration's been given to all members of both the House and the Senate for good policy ideas, and you will see some of those in the form of language that's contained in the document that we have before the body today. And to your point, yes, that contains proposed amendments that were adopted by Republicans and Democrats during the regular session in the course of discussing an election integrity and security bill.
And there's a lot of false accusations made about members of this body and, quite frankly, you. Have you had an open door to any member of this body to discuss this bill and listen to their ideas?
Yes, sir. I have repeatedly indicated to my colleagues that my door is open, my phone is available. I'm always happy to sit down and listen to their concerns, try to answer their questions, along with any constituent or stakeholder groups that they may have that are also visiting with them about this important issue.
One of the things that I noticed is that there was language around, former language around quote-unquote purity of the ballot box that was removed. Was that an amendment by Mr. Johnson?
So during the regular session, there was discussion on a similar piece of legislation that did contain a similar provision. And at that point in time, Representative Jarvis Johnson offered a floor amendment to remove that language. And so the language following his amendment has actually been incorporated into the document that we have before us today.
Was there also an amendment with respect to the right for a defendant to be instructed regarding how a felony conviction will impact the defendant's right to vote?
Yes, that is correct, and that is contained in the Senate Bill 1 that's before us today.
And based on my reading, that was an amendment by Mr. Busey, is that correct?
That is my recollection as well, yes, sir.
Was there also an amendment to this piece of legislation by Ms. Gervin Hawkins that gives a voter the opportunity to correct a defect mail-in ballot like we were just talking about? Was some of those provisions that we just discussed, was that actually from Ms. Gervin Hawkins?
Yes, as I identified earlier, we worked hard to pay attention to good ideas regardless of where they originated from this year, and a lot of those ideas percolated to the top during the regular session, and those components were placed into SB 1 that we have before us today.
Was there also an amendment, I believe from Mr. Turner, requires registrars to coordinate to update the address of a voter if they move to another county?
Yes, that is correct.
So there have been multiple amendments to this bill by both parties, including the party that left the state of Texas and accused us of voter suppression and racism. Yet you have amendments from several of those individuals, a lot of their language in this piece of legislation. Is that correct?
Yes, and I'll simply clarify, you mentioned amendments. Those aren't floor amendments that we're considering today.
That's right.
Those were proposed floor amendments on past legislation that we used as a basis to craft the policy discussion document piece that we have today called SB 1.
Yeah, they went through the bipartisan process that we've always exhibited on this floor when any member can either go to the bill author or you can go on the floor and offer an amendment. That process was respected for both parties. Is that correct?
Yes, I believe so. That is correct.
What about the idea, there was a change recommended, and it looks like that it got into the piece of legislation from Mr. Vo that extends protections afforded to workers that allows those who wish to vote to take off work without any retaliation from employers. Is that in this piece of legislation as well?
Yes, sir. And if I may explain, current Texas law actually provides protections for an employee to take off from work on election day. And Mr. Representative Vo's amendment that was made during previous legislation during the regular session is incorporated into the SB 1 language that you have before us today to afford that protection during the entire early voting period. So no longer, if this passed, no longer would an employee simply be protected on election day, but the employee would have those protections from his or her employer during the entire 2 weeks of early voting to be able to take off work and go vote.
So based on the provisions that I've talked about, based on the provisions that came from the Democratic Party, and there's been other provisions, it sounds like, how is this bill suppressing the vote?
I do not believe that this bill suppresses votes.
I don't think it does either. Mr. Murr, I know this has been a challenging time for you. It's been a challenging time for all of us. I really appreciate all the work that you did, the respect, the openness. I'll be voting for this bill. I'm the grandson of immigrants. I would never, obviously, suppress my own vote. This bill doesn't do that. Those are falsehoods. And I'm looking forward to voting for your bill. Thank you for all your work, Mr. Chairman. You've done a stellar job.
Thank you, sir.
Thank you.
The gentleman's time's expired. Mr. Turner, for what purpose?
Move to extend time.
Members, this is a reminder to everyone to be civil and respectful of our colleagues as we debate SB 1. The chair would appreciate members not using the word racism this afternoon. Mr. Turner has moved to extend the gentleman's time. His objection, chair hears none, so ordered. Mr. Turner, for what purpose?
The gentleman yield for some questions.
Would the gentleman yield for questions?
I yield.
Gentleman yields.
Thank you, Chairman Murr. I have several questions. Your bill includes the word fraud several times, including in the caption and in the bill's legislative findings section. Could you detail for the body how many instances of election fraud occurred in the 2020 election in the state of Texas?
I don't have that information in front of me, although I do know that there were resource witnesses with both the Texas Secretary of State and the Office of the Attorney General during the committee hearing that may have been asked those questions. But the focus of this bill is forward-looking, and if you'll notice when we talk about fraud, at least in portions of that you referenced, it has to do with the likelihood of fraud.
Okay, but you're not able to identify how many instances of fraud may have occurred in 2020?
No, sir, and I don't necessarily believe that fraud is a condition precedent for implementing a good policy.
So the director of the Secretary of State's Election Division, I think you just referred to, stated in committee testimony during the regular session that in 2020, quote, Texas had an election that was smooth and secure, unquote. Do you agree with that assessment?
I agree with that assessment, as I have stated in the past during committee hearings, yes.
Okay. Now, let me go back to fraud. Have you read about or been briefed at any time about the results of Attorney General Ken Paxton's election fraud investigation efforts in the 2020 election?
Only what I overheard during the committee hearing process from witnesses and questions asked of the resource witness from the Office of Attorney General.
So you haven't met with General Paxton or his staff about those findings?
About those findings, no, sir, I have not.
Okay, have you met about other things?
Only in response to specific questions that I have asked, which were very narrow in scope. So I have not touched upon any discussion about that process that they undertook in 2020.
Are you aware that the AG's office, this has been publicly reported, I believe in the Houston Chronicle, that the AG's office spent 22,000 staff hours on those so-called voter fraud investigation efforts in 2020?
I may have observed that article, but I will take your word for it that is the statements made in the article.
So the Attorney General's office didn't bring any data to you with respect to their 22,000 staff hour investigation?
Not to my knowledge, no, sir.
Okay. Were you aware that they increased the staff number of their voter integrity unit to 17, which is a total of an additional 8 employees, so nearly doubling in size? Were you aware of that?
I was aware of that following questions during the committee hearing process of the resource witness for the Office of Attorney General, yes.
Okay. And do you know how many prosecutions were a result of all that extra staff and staff hours?
I believe that also arose during the committee hearing process. Off the top of my head, I don't have that in notes in front of me.
Okay. I'll represent that it was a total of 4 prosecutions to date. Does that sound right?
I would not disagree with you.
All right. And so is it correct that there were, when they looked at instances of so-called fraud, that they in fact found 16 total instances, again, this is not prosecutions, just instances of fraud they've identified, each having to do with a voter listing an incorrect address on a voter registration form. Is that accurate?
I don't recall that specificity. I will tell you there was some discussion between the difference in the number of individuals versus the number of counts that were raised against them in various different cases. So I'd have to take your word for it. I don't know, Mr. Turner.
Okay. So with respect to your bill, did you or did the committee at any point do any sort of impact analysis, specifically a racial impact analysis, and how this bill could impact voters of color, specifically African American and Hispanic voters in the state of Texas?
No, sir.
There was no impact study done?
No, I was asked that repeatedly during committee by members of the committee by members of the committee, and my answer remains the same, no.
Okay, why was no study conducted?
I don't know that a study is required, but I'm not aware of any disproportionate impact studies that are currently in existence. Nobody's made me aware, although I have implored my fellow members to share any information that they may have that may be helpful during this process.
But you didn't make any attempt to initiate such a study to ensure that there would not be a disparate impact?
I did not make an attempt to initiate a study, no, sir.
Okay. In the regular session, you'll recall, I think, that there was a lot of discussions about the conference committee report on Senate Bill 7 and some specific provisions that were added into that bill in the conference committee report at the very end of the session. Specifically, a provision relating to overturning elections and another provision that limited Sunday early voting hours that was widely seen as an attempt to target Souls to the Polls programs that a lot of churches run. Do you recall those provisions?
I certainly do recall the discussion, and I recall hearing about those provisions. Yes, sir.
Okay. And are those provisions in this bill today?
No, sir. And if I may expand upon that just a little bit, there are prescribed start and end times during Sundays that you will find in this bill, but I understand that no one has raised any objections that would impact Souls to the Polls. In addition to that, specific language about the judicial overturning of elections without considering or determining how individual voters voted is not contained in the legislation before the body today.
Okay, thank you. So, back to those provisions, have we established where those provisions came from in SB 7? And I ask that because I've never heard a definitive answer where those provisions came from. In fact, in a press conference on July 21st, the Lieutenant Governor said that the Senate, he said very definitively, the Senate did not put that in there. So do we know where those provisions originated from?
I do not know where those originated from, and Chairman Turner, I also wasn't part of that process. I wasn't part of the committee at that time, and so I have no background knowledge or idea.
Understand. The reason I ask is I think it remains of great concern to a lot of people how those provisions got in the conference committee report on SB 7 to begin with, especially since no one has to date, 3 months later, claimed any ownership of those provisions. So my question is, how can the body be assured that the provisions of SB 1 that we have before us today were not authored or constructed by the same folks who put in those provisions in SB 7 that no one's willing to claim credit for?
How can the body be assured of that today? I think the body can pass a good piece of legislation off the House floor and the Senate concur with it.
Okay, so we don't know for sure then if whoever put in the provisions relating to Souls to the Polls and overturning elections in Senate Bill 7, we don't know for sure that those people were not involved in writing Senate Bill 1.
I played a role in drafting Senate Bill 1 that you have before you, and I can tell you that those provisions are not contained in this document, and I have no desire for those provisions to be contained in this document. And you ask, how can we have assurance that they won't show up later? And I say one really strong way to do that is for us to not have a conference committee. And we pass quality legislation off of the House floor, and it goes to the other chamber, and the other chamber could concur. And that's one method in which you would have assurance that there wouldn't be any changes made in a conference committee.
Right, and I think my concern right now is simply that if those provisions were written by folks who also had a hand in writing this bill that we have before us today, my question is if that at some point was proven to be the case. And it may not be, but it sounds like we don't have the answer to that information right now.
Well, let me make another distinction, if I may interrupt. I'm now part of this process as the sponsor, and so I wasn't part of that process previously, and so you have an assurance from myself, the sponsor, that I have no interest in seeing those provisions show up in any bill.
If it turned out later that there was a connection between people that helped write those provisions and helped write this bill, do you think that would undermine the integrity of this bill?
I'm not advised, Mr. Turner, as to whether that would, but I can tell you based on this bill and my hands-on experience in being the sponsor of this bill, I'm confident that we're not going to have those provisions in this bill.
Thank you.
Yes, sir.
Mr. Speaker.
Mr. Busey, for what purpose?
Will the gentleman yield for a few questions?
Would the gentleman yield for questions?
I happily yield for questions.
The gentleman yields.
Thank you, Mr. Murr. Just to follow up on that final point, we've seen some amendments that would counter that and would attack souls to the polls hours today. Can we take from your dialogue you just had that you will oppose any amendment that would restrict the hours of souls to the polls?
So may I provide a little background information and context for our colleagues that are listening? So in the legislation that you have before us today, it expands the hours from 5 hours to a minimum of 6 hours on Sundays. There's a Sunday in between the 2 weeks of early voting. And it also puts a start time of 9 a.m. and an end time of 10 p.m. for the local jurisdiction to determine when the best hours would be. And I provide that for
I just
context.
want to make sure you will oppose any amendment that would raise that start time on a Sunday to, let's say, noon, as we've seen amendments filed to that today.
I believe that a start time of 9 a.m. and an end time of 10 p.m. with flexibility of local jurisdiction as crafted before you today is the best policy for us to consider.
Let me ask a couple quick questions. I know we got limited time. Under current law, local counties get to decide voting hours during early voting. Are there any restrictions to those hours under current law?
Under current law, it states, for example, for many counties, that a minimum of at least 8 hours needs to be made available. For example, during weekdays.
But it doesn't set what hours those can be.
That is correct. There is not an express prohibition against more than 8 hours.
So counties can set their own hours within the 24-hour realm as they choose under current law. Does this bill take us backwards on the hours that a county can choose to serve?
No, actually, it guarantees additional hours that would be available as minimum hours.
As minimum hours. I'm talking about maximum hours.
So
right now, a county, as we've seen done, can have voting up to 24 hours during the early voting period. We've had questions from our colleague. Does this bill, what are the parameters in this bill for during early voting for hours that can be voted?
So, and you've got several points that you make there. Let me try to address one, and if I didn't answer it correctly, please ask me again. You mentioned about the 24 hours. I'll point out, and Representative Busey, as a member of the committee that heard this legislation both during the first and the second called session, that you heard resource witnesses from the Texas Secretary of State explain that the concept of 24-hour voting, or more than the 8 hours that was minimally required under current statute, is what was a novel idea that was applied by a jurisdiction during the 2020 pandemic, but has not happened in the past across the state.
But it's allowed under current law to do so.
It is not prohibited under current law.
So we've had people have access to 24-hour voting, and this bill will do what to those hours? What are the parameters?
This bill prescribes a start time and an end time during the early voting period, which is 2 weeks and the weekend in between.
Well, and I appreciate your history because we've all heard celebration about how Texas has such early voting. My point in these questions is, under this bill, correct me if I'm wrong, the maximum amount of time allowed is 16 hours in a day for early voting. Is that correct?
For each weekday during early voting, that is correct.
16 hours. And current law allows up to 24. So we are regressing access by 1/3 of the early voting period. So as I've heard our colleagues celebrate our early voting period, it should be noted that this bill will take away 1/3 of that early voting period. I have one other question for you. One of the goals you set out is uniform and consistent across the state. What are the minimum voting hours in this state under this bill if it becomes law?
The minimum voting hours that are based in here during the weekdays would be a minimum of 9 hours with a window of 6 a.m. to 10 p.m. during weekdays. On Saturdays, from 6 a.m. to 10 p.m. and on Sundays from 9 a.m. to 10 p.m. with minimum hours of 5 hours.
Is that true for all 254 counties?
No, sir, that is not. Current law actually prescribes a breakdown based on the population size of counties and even a little further when jurisdictions where there is less than 1,000 registered voters. And I know that you're aware of that because oftentimes that is based on the availability of poll workers, many of which are volunteers. And each jurisdiction has some flexibility to design in this because they are, as a state sets some guidelines for that. We also, there's some deference given to local jurisdictions to design that around the needs and wants of their local constituents.
My concern is in a bill that's aimed to have uniformity, we're not solving that problem, and our rural voters are not being guaranteed the same minimum of access to the ballot box as our urban and suburban voters, if this bill becomes law.
I disagree with that conclusion. I don't think that we've heard witnesses in rural areas say that they have a limitation of access to the ballot box during their 2 weeks of early voting, the weekend during early voting, and the election day of 7 a.m. to 7 p.m.
Whether we heard it or not, this law as written would have different minimum hours for our smaller counties, thus not inherently guaranteeing them the same hours of access that we give our urban and suburban counties.
Current law already prescribes that in the state of Texas.
It already prescribes that you can give smaller counties less access. I'm just saying in a bill that's designed to create uniformity, this is an area where we are missing that. So if we bring an amendment,
I would assert
you would consider
I'm
that.
sorry.
I was saying if we bring an amendment, would you consider creating that uniformity across the board?
No, sir, I would not. I believe the bill tracks the current framework that we put in place.
All right, thank you.
Mr. Speaker,
Mr. Dutton, for what purpose?
would the gentleman yield?
The gentleman yield.
Yields for questions.
Gentleman
Yes,
yields
sir.
for questions.
Thank you. Let me start by thanking you for meeting with me. I think we met in my office about a couple hours almost to talk about Senate Bill 1. Let me ask you, when you laid out the bill, one of the purposes that was not in the bill was about increasing access to voting. And the purpose, one of the purposes ought to be to increase voter turnout in Texas. Are you aware of where Texas ranked in all 50 states in terms of voter turnout?
No, sir, Chairman Dutton, I am not.
Well, I've heard that we were 45th out of 50 states in terms of voter turnout during the last election. And it seems to me one of the purposes ought to be in the bill ought to be to increase voter turnout. Would you agree with me?
I would say inherently in a democracy such as ours, we yearn to have every person that has a constitutional right to vote to exercise that right. Yes.
That's right. And so you wouldn't mind if we amended so that the purpose actually would envelop that.
I can find numerous instances contained in the provisions of SB 1 before you today that I believe improves voter access. And
well,
I'm sorry, just let me finish my one statement. And in the legislative intent that we talk about, we actually talk about promoting voter access.
Yes, but what I'm getting at is the purpose of the bill. When you laid it out and you talked about the individual things that involve the purpose, that's one of the things that's excluded. It's not included in the bill, such that, as you said, in a democracy, we ought to have everybody voting. And certainly if Texas is 45th in voter turnout, we ought to be thinking about that in terms of trying to improve that. I mean, wouldn't you agree with me that that's one of the purposes ought to be to increase voter turnout in Texas such that we get people where you have created in the bill, you say access to voting, more access. We ought to make sure that the purpose at least follows that.
And I think I understand where you're going with it, but I go back to our legislative intent of promoting voter access, and I believe multiple provisions here do that. And just because folks have rights, we don't always see them choose to exercise their rights, and I understand that as well. And that can be frustrating for our friends and neighbors because they decline to participate in the process.
Right, but we ought to be encouraging not only the way we could increase the number of hours without creating an increase in voter turnout. And what I'm getting at is while we increase the access, or while we do something about that in the bill, what we don't do is about, in terms of the purpose, of increasing the voter turnout in Texas?
You know, Chairman Dutton, that makes me think of a phrase that my grandmother used to tell me, and it's common to all of us, is that you can lead a horse to water, but you can't make him drink. The concept is the same. Just because folks have the right to vote doesn't mean that we can force them to vote.
But you can encourage them to drink. I mean, you could give them salt or something, and they'll go drink. Is the point that my grandfather used to say too. And I heard that. But I just wondered if if democracy revolves around all of us participating, we should be involved in trying to make sure and ensure that people actually participate in the democracy by increasing the voter turnout. And that's all I'm suggesting.
And I hear you, and I think that is something that individually you and I take on that task to encourage our fellow neighbors and friends and family members to participate, but I don't necessarily believe that is the state's responsibility to actively force everyone to go vote.
No, I don't mean force. I mean just do something that's creative that helps people access their right to vote. And while you increase the access, as you said, what we don't do, on the other hand, is, at least in the purpose of the bill, suggest or encourage people to go out to vote.
And there's a fine line there between the state suggesting, encouraging, or forcing folks to exercise their right to vote and folks individually choosing to do so. And I think that's a choice issue that we have, and I understand that.
Right.
I guess where you're going with it is perhaps the state becoming some active player in requiring or forcing or encouraging folks to go vote versus us having a system in place and folks choosing to participate in that election system.
Right. Well, actually what I'm talking about is just in the purpose itself, as you laid out, that's in the bill. If we could put in there trying to increase the voter turnout, I think is what I'm getting at.
I understand, and I'm happy to have dialogue with you on that, although I'm not necessarily in agreement right at this moment.
All right, thank you.
Yes, sir, thank you.
Wait, don't do that, Mr. Speaker. Don't hold it up right there. Will the gentleman yield for a question?
Ms. Davis, for 1 second. Gentleman's time's expired. Is objection to extension of the time? There is not an objection. Ms. Davis, for what purpose?
Thank you. Will the gentleman yield for a couple of questions just as a follow-up and for legislative intent?
Will the gentleman yield for questions?
I yield to the gentlelady for questions.
The gentleman yields.
Thank you. Chairman Murray, you talked about in the discussion with Representative Busey about the intent is to allow local control or local considerations to help define what the actual hours would be for voting. And I just want to make sure that I heard that right, because from a legislative standpoint, we've been usurping local authority. And so is this bill, is it your intent in this bill that we would not usurp the local authority and in fact allow the local election administrators to define what the hours should be for that particular location?
To answer your question, this legislation builds upon existing statute. Existing statute prescribes a minimum number of hours during the day, during the early voting period, in which a local jurisdiction must have elections available for folks that choose to vote early in person. In addition to that, this bill provides a start time and an end time, and then provides the flexibility for that jurisdiction to choose what time frame will work best for their jurisdiction. So I think what you're finding is we're building upon existing law that the state has already put in place, and that policy has been to provide some consistency because we understand how it's going to be across the board, but at the same time some flexibility at the local level to figure out what works best for the voters that want to show up to vote, as well as the availability of poll workers, volunteers.
And so let me restate my question.
Yes, ma'am.
And I need a yes or no, please. Based on your conversation with Representative Busey, you said you're building on existing law, but that you have allowed the local jurisdictions to define what's appropriate for their area. So my question is whether or not it is your intent that this legislation would always allow for local jurisdictions to define the appropriate hours and processes for their jurisdictions as it relates to setting the framework for early vote?
Yes, it is my intent to allow this piece of legislation to provide local jurisdictions the ability to determine the hours within the framework that is in the statute, that is in the proposed bill provided by the legislature.
And my last question as a follow-up to that, as it relates to this discussion with local jurisdiction, do you envision or do you see where we might come back as a legislature and attempt to usurp the authority that you've given the local jurisdictions? Because we've had bills like that. I just want to make sure it is your intent that that will not happen in this legislation.
Representative Davis, I can't speak to future legislators.
No, I mean this session, this legislature.
This legislature, I do not believe that there is an intent to come back and modify things, but I will point out, as I did in my layout, that the state of Texas constantly reviews the election laws that it has to determine what works and doesn't work amongst changing dynamics that we have. So I always think that it is the intent of the legislature to consistently and constantly review policy that's put in place to see if it's working well or if it needs to be modified, changed, or updated.
And there's no question that we have that ability and we do that. I just want to make sure that as we move forward in this legislation, it is your intent that that would not happen in this bill today.
It is not my intent for that to happen today. That is correct.
You.
Yes, ma'am. Thank you.
Ms. Speaker, I'd like those remarks reduced to writing so that we might have a record of that between this discussion as it relates to intent.
Yeah. Members, you heard the motion. Objection. Chair has none, so ordered. Mr. Wally, for what purpose?
Would the gentleman yield just for a few questions?
The gentleman yield for questions.
I yield for questions.
The gentleman yields.
Thank you, Mr. Murr. Just to go back to some of the provisions of the bill, just the plain meaning, particularly of some of the language on prohibition of drive-through voting. Are you familiar with the drive-through voting component of it?
Yes.
So are we, in this bill, are we prohibiting drive-through voting in this bill?
And I hate to ask you a question, but just for purposes of clarification, when you talk about drive-through voting, are you talking about current lawful curbside voting that's allowed by state and federal law?
Yeah, so what I'm talking about is particularly in the structure part, right? So what we did in Harris County was, in response to COVID, the county tried to make it simple so that folks who had a fear of contracting the virus had an opportunity to, use a temporary structure to be able to vote. Are you aware of that?
I am aware of that, and there was testimony during the hearings that spoke to that topic.
Okay. And so because in the bill, I think, it talks about structures and it prohibits temporary structures. Is that correct?
That is correct. And do you have a specific provision that you want to point to? So just so I make sure I'm on the same page?
I think we are on, excuse me. There we go. Hold on a second. So on page 20, I think it talks about Section 3.11 take that back. Section 3.12B, it talks about a polling place established under this section may be located subject to subsection B at any place in a territory served by early voting clerk, may be located inside any building, and then it strikes stationary structures. Are we trying to prohibit a particular polling location that may have set up a tent next to the county building? Because I think this is the county building. Is that my understanding?
So Section 3.11 relates essentially, and if you talk to the Secretary of State, relates to the clerk's office during early voting.
Right.
Section 3.12 relates to any other voting location during early voting. And the purpose here is to explain that voting needs to occur inside the building. And if you go back to the premise or the policy argument behind it is We've heard several folks speak about the constitutional right to vote and how we hold that as very important. Protecting the secrecy of your ballot and providing you a place to do that in private is very important. When you locate that process outside of a secure place where it's not necessarily available to you, then there's a potential that your ability to vote is not in private and may be compromised. And so that's the purpose. Okay. So I just to clarify, because I certainly don't want to be coy with you, this bill explains that the right to vote from your voter vehicle exists under the current rights prescribed for curbside voting. And curbside voting is limited to those that are eligible to vote for curbside voting, but it's not provided to all persons. And this bill doesn't expand upon that.
Right, but I think the effect of what we did in Harris County with this bill, particularly for folks that had a credible fear of contracting the virus, that they were allowed to vote in their car, very conveniently, vote in their car so that they wouldn't contract the virus. Because part of the impetus for what we did in Harris County was that we were trying to protect public safety. And one of the reasons we, expanded curbside voting, expanded 24-hour voting, and allowed folks to have an opportunity to have, particularly just the mail ballot application be sent to voters, which initially was subsequently backtracked, was to allow folks easier access to the franchise during the pandemic. You're aware of that? Is that your understanding?
I'm aware of that, and I think you've got two topics here. If you want me to talk about curbside voting, or if you want to talk about the application to vote by mail. I mean,
no, I'm talking about all of it, but
yes,
it pertains to curbside voting, because what's happened in Harris County was that we did some, use your term, some novel creative ways to access the ballot, but in this bill now prohibits it by prohibiting drive-through voting and 24-hour voting, and so that, and temporarily early voting locations that are not located inside a building. So I'm just trying to make sure that we understand that, and the public understands what's going to happen with this bill once it is implemented.
Yeah, and I will clarify for you that this bill provides that a person can vote from their automobile pursuant to section 64.009 if they're physically unable to enter the polling place without personal assistance or likelihood of injuring the voter's health, which is what we currently use as curbside voting. Okay. And so it doesn't touch that, and it's also protected by federal law, but it doesn't expand upon the ability for you to vote from an automobile if you don't meet the criteria of current curbside voting, which I get to is maybe that was a novel approach that was tried in Harris County. It's not expansive to include that for every person. They still need to meet that criteria of 64.009.
Got it. I want to turn to page 37 of the bill as it relates to unlawful solicitation and distribution of an application to vote by mail. Page 37. And so in the bill, would you say that we are creating a new criminal offense in this section?
Yes.
Okay. And would that be a state jail felony?
Yes.
Okay. And could you describe what, in the bill it talks about Section A, public official, an election administrator, not to be coy with you, but an election administrator would be a public official. Is that correct?
I'm gonna clarify that. I have a perfecting amendment in a minute that actually brings that term in, because a public official may not necessarily include a non-elected elections administrator. And so my perfecting amendment would include that in the definition.
Okay.
So assuming that the perfecting amendment later is considered and adopted, then the answer would be yes, this provision would apply to a public official or an elections official.
Okay. And so with that in mind, just using, without your perfected amendment, a public official now, if they choose to send or solicit the submission of an application to vote by mail from any person that did not request it, if they should choose at their discretion to send just, not the ballot, but just the application to vote by mail, that would be an offense and up to a state jail felony. Is that correct?
That is correct. The language here expressly states that they're not supposed to send it to someone who didn't request it. Now, alternatively, the policy goal here, and I've explained this in committee, is our system is designed upon activity by the voter. The voter has to request it. And therefore, the voter is watching for what's coming in the mail and paying attention to that important piece of mail, that application to vote by mail.
Okay, so the voter then now has to, without, but in this section, we are creating a new criminal penalty up to a state jail felony for a public official who sends this application unsolicited to a voter.
That is
voter.
correct. Yes,
Okay.
sir, that is correct.
Okay.
And I just go back, the policy goal there is Texas, its policy is passive. A voter has to request that application to vote by mail. We are not an active or proactive state policy of distributing all of those to everyone all the time. And so that's what this is following.
Okay, I guess, could you explain that a little further? Because I'm trying to understand why we would make a policy decision to make it a state jail felony to encourage folks to, for all intents and purposes, participate in the franchise. Anybody, any Texan, whether they're Democrat, Republican, or Independent, disabled, why would we do that?
So some of the testimony that we heard during the committee hearing process, as well as input from stakeholders and individuals, raised concerns that if a potential voter is not aware of the document that's headed their way, then, and I go back to our legislative intent, you have a scenario where you could have the likelihood of fraud because that application to vote by mail has been sent out. They're not aware of it. And we all know that outside the ballot zone where you vote, you know, you're gonna have paperwork that's coming and going. And so at the end of the day, the policy is for it to be a passive system.
So you said likelihood of fraud. That was a key word for me. What do you mean by likelihood of fraud? Are we implying that because somebody gets a unsolicited application that there's going to be a likelihood of fraud?
No, I'm going back to the legislative intent where we talk about the purpose is to reduce the likelihood of fraud. And when you vote in person...
What would be the likelihood of fraud?
If I may, when you vote in person and you go in person and you vote, your ballot never leaves the voting location. When you vote by mail, your ballot is, first you're going to have an application to vote by mail with potentially confidential information that's going to be returned, and then your ballot by mail is going to be sent out, and it's also going to be returned. And so because that ballot is unaccompanied compared to in a scenario where you go to a polling location and your ballot is, there is a potential, as we've heard from input from folks, that there could be a likelihood of fraud. And so but efforts made to ensure that our policy protects against that works to ensure security in the overall system. And that provides...
But what I'm trying to understand, though, is this is just the application itself, not the actual ballot.
That is correct. Yes, sir.
So where in that process of an elected or appointed, future appointed official, public official, how do we not trust that person, usually a person that's a career official, to just send the application itself to the voter? It's not the ballot itself, it's just the application for them to have the opportunity to get the ballot. Where in that process is there a likelihood of fraud being committed?
I believe I've answered that. And that is the fact that unlike voting in person, where your ballot is contained in the environment that we hold sacrosanct, voting by mail, and thus your application to vote by mail, includes personal information, And it also has to do with your ability to exercise your right to vote. And so it should be initiated by the voter. But that's the policy goal.
Since the inception and up till now, my understanding is I'm with you. That is a sacred, the right to vote, that secrecy, being in a booth and having that opportunity to vote is sacred. But it's just as important for somebody that's maybe a senior, maybe a veteran, maybe disabled, to have that same opportunity in their home, to have that ability to at least just receive the actual ballot application, let alone the actual ballot, but just the application itself.
And they have the right to receive that application as soon as they request it. Okay.
And then the following page, on page 38, section 276.017, unlawful distribution of early voting ballots and balloting materials. We're also making it, and I'll just read it verbatim, the early voting clerk or other election official commits an offense if the clerk or official knowingly mails or otherwise provides an early voting ballot by mail or other early voting by mail ballot materials to a person the clerk or official knows did not submit an application for a ballot to be voted by mail under section 84.001. The section right under that is creating an offense under this section is a Class A misdemeanor. Is that your intent in that bill as well, is creating a Class A misdemeanor on this offense?
Yes, sir, you have read it correctly, and yes, it does create a new criminal offense.
Okay.
And
Thank
that
you.
criminal offense is of no concern if the early voting clerk or other election official follows the law and does their job. It has a knowingly requirement, so they have to know.
But you're also creating another penalty for election officials who send out early vote materials, balloting materials as well.
That is correct, to someone who didn't request it. That is correct.
Okay. Thank you.
Mr. Speaker, will the gentleman yield for some questions?
Certainly yield.
Does the gentleman yield?
Yields for questions.
Thank you, Chairman Murr. Just wanted to run through a few questions and really kind of follow up on what Representative Walla was discussing with respect to voters in Harris County who had used the drive-through vote centers during the 2020 election. Do you recall that the Harris County Election Administrator testified before the committee during a hearing on SB 7 and HB 6 that approximately 53% of the votes cast at the 10 drive-through sites available during the 2020 election were by people of color? Are you familiar with that data point?
I was not present during the testimony during the regular session of the committee hearing, so I will defer to you in assuming that data point as you describe it is accurate.
Yeah, of the 127,000 voters, Republicans and Democrats, who cast ballots via the drive-through centers in the 2020 general election, keeping in mind that we were in the middle of the deadliest pandemic of 100 years, or in 100 years,